My name is Anand Shah, and I am the Vice President for Victims of the ICC Bar Association. We are delighted to have all of you with us today for this virtual panel discussion on the intersection of disability with international humanitarian law and international criminal law. And let me start by extending the warm greetings and apology of the ICCBA President, Marie-Hélène Proulx, who had very much wanted to be present. And I know she'll be very eager to watch the recording of this event via the ICCBA website, as will many more of our members who had expressed an interest in attending but couldn't make it at this time. So turning to the subject of today's panel, persons with disabilities face, I think as we all know, heightened vulnerability and difficulties in armed conflicts and other humanitarian disasters. Notwithstanding this, academic debates and legal discourse, including at the International Criminal Court, often neglect or give limited attention to the status and unique challenges faced by individuals with disabilities in these contexts. The same cannot be said, however, of our three distinguished panelists today. They are lawyers, advocates, and academics for whom the legal and practical aspects of disability are of central importance and focus to their work and their lives, including in the context of IHL and ICL. So firstly, we have Christina Warner. Christina is a barrister in England and Wales, a disability advocate, and a member of the Bar Council of England and Wales Disability Panel. She also has experience working at the ICC as a former visiting professional. Second, Janet E. Lord. Janet is the executive director of the Center for International and Comparative Law at the University of Baltimore School of Law and a senior fellow at the Harvard Law School Project on Disability. And last but certainly not least, William Pons. Will is a fellow at the Harvard Law School Project on Disability. And Janet and Will have also authored a number of publications relevant to our discussion and have kindly provided a short handout, which includes links to some of the recent work. And I think you should have received this document by email, but if not, just please reach out to our wonderful executive director, Dominic Kennedy, and he can provide you with a copy. And we will hopefully have a little bit of time at the end of today's discussion for some questions from the participants. And what may be easiest, if you have any questions, you can perhaps put that in the chat, and hopefully we'll have a chance to address some of those at the end of our discussion. So I know our time is short today, so let us hear from our amazing panelists. And Janet, I'd like to turn to you first, if that's okay. And it would really be helpful, I think, for all of us to have some background and a framework to better understand today's discussion. So firstly, can you provide us with a brief history on the development of disability as a legal concept? And secondly, connected to that, how is disability defined or understood as a matter of law, including in international instruments?
Sure. Thank you so much. And I'm so delighted to be here because, you know, sometimes the stars align amazingly. And this is work that we've been doing at the Harvard Law School Project on Disability, doing a whole line of research. But the opportunity to connect with people who are actually steeped in the practice of international criminal law, it's truly a dream come true because you all know exactly what it takes to operationalize some of these issues. So we're excited to learn from you. So I guess I'll start by saying that we do know that more than 15% of the world's population has a disability. And it's disability is of course very widely prevalent in fragile and conflict affected societies, and going much more beyond the 15%. And we also know that in such societies that are fragile, that are affected by conflict or recovering from conflict, fewer than 3% of persons with disabilities in those societies have their rehabilitation needs met or their health needs. Many are denied an education explicitly by law or other types of barriers. They're segregated in their communities, either in their homes or in dehumanizing institutions, and their human rights abuses go largely unmonitored and undocumented. So the inequalities that prevail in peacetime for people with disabilities everywhere means that risk is severely enhanced during conflict, when we know that human rights violations of IHL occur. So the history of actually accounting for persons with disabilities in law is largely one of exclusion, right? So disability was used as a specific category of exclusion in a myriad of laws. In my own country, which is the United States, for example, it was an explicit category of exclusion in immigration law right up until the 1970s. If we trace the development of disability rights, we can kind of see in the 1800s, the founding of formal education for deaf persons, for deaf-blind communities. We see the invention of Braille, but progress was nonetheless very limited. So in my country, we have in 1907, the eugenic sterilization law. So mass sterilization of people with disabilities was enacted in 24 of the United States, which allowed for sterilization of people with disabilities. The United States Supreme Court declared in a very famous case, Buck v. Bell, that 3 generations of imbeciles was enough. And that essentially put the imprimatur of legitimacy on sterilization. This was the Supreme Court of the United States in the 20th century. Now, we did see important developments with regard to veterans with disabilities post-Civil War in the United States, and in other parts of the world. World War I, World War II, were starting to bring in programs that were addressing to some extent the needs of veterans with disabilities. We see certainly the evolution of social protection laws and things like that, but disability was long a basis, and remains the case in many countries, the basis for forced institutionalization. Plenary guardianship laws continue to strip people with disabilities of their legal capacity. That is starting to shift. We'll say more about that. But essentially, it's a rather long and lurid history of exclusion and or invisibility, right? So in laws that are designed to protect civil rights, political rights, economic, social, and cultural rights, often we don't see a whole lot, except maybe in the very narrow confines of a welfare protection, right? So that's really the history, and that history prevails in North America, Europe, and in developing countries. What we have seen, even in the very early years of the 2000s, very little development of disability law at all. And where it did, where disability was addressed, often they're in old colonial statutes like the Lunatic Detention Act, for example, in the Gambia. And that was a case that went before the African Court of Human Rights, and very progressive decision. But that's kind of been the either no law or very antiquated law that was very exclusionary. So that's our history, right? And if we look at international human rights law, where we would think, well, that there's must be something there, well, there really wasn't much of anything up until the adoption in 2006 of the Convention on the Rights of Persons with Disabilities, one of the core international human rights conventions. Why did we need a convention on the rights of persons with disabilities? Because of the invisibility of people with disabilities in international human rights law and practice. I had the amazing privilege of a lifetime to participate in that process. And it was a bit of a tall order at the beginning to get countries to come on board with yet another elaborated convention. There was, many felt that there wasn't the need for this. People with disabilities are already covered, at least implicitly, right? But we know the story of invisibility meant that, in fact, the UN human rights system itself wasn't doing anything on disability. Disability organizations were not engaged in human rights processes regionally or internationally, and so forth. So there was a need, thanks to Mexico. Mexico is the state that started the entire process back in 2001 with a General Assembly resolution. That process took off and ultimately led to the adoption of the convention. And for the first time, we start to see concepts reflected in some of the more progressive disability laws elaborated in the late 1990s in many countries, starting to be imported into international human rights law. So that was incredibly important, obviously, to sort of fill in the gaps. The missing part of the international human rights puzzle started to be filled in a bit. And in the convention, we see disability rights contextualized, right? For persons with disabilities, or human rights contextualized for the actual lived experience, the multitude of barriers that people with disabilities face. So that was an incredibly important development, and because I have the benefit of having participated, and being around for a long time, I can say that a lot has happened, and it's been a treaty that has really ushered in domestic law reform, perhaps unlike any other human rights convention, because there was so little, or because the exclusion and the discrimination legislated was so significant. So what does this mean? What are the implications of this treaty for international humanitarian law, for international criminal law, for international refugee law, for these other domains of international law where disability was either missed or problematically framed, right? So when we look at IHL and how disability has been defined in international humanitarian law, we see that people with disabilities are protected people. They're subjected to specific and general protections under IHL. Commentators sometimes miss that altogether. Why is that? Well, because we have people with disabilities being variously referenced, but not using consistent terminology, certainly not using human rights-based terminology around disability. So we see terms that might denote disability kind of all over the place in IHL. So we might see terms like, sick, wounded, maimed, mutilated, blinded, mentally diseased, but very rarely disabled, right? So, so it's kind of all over the place and at the same time, kind of nowhere. So that, of course, has been a problem. And I had an interesting experience right after the treaty was adopted, meeting with folks at the International Committee of the Red Cross, along with another colleague of mine who brought along the language of the convention. And it was a really interesting moment because the three lawyers at the ICRC looked at the provisions set out in the disability treaty and saw that international humanitarian law was actually referenced in the treaty, right? So that was a aha moment when the ICRC decided we better do something because IHL is specifically referenced in this treaty. Oh my gosh, we had no idea. So in how is disability understood and conceptualized in the convention becomes really important for thinking about its conceptualization in international criminal law, international humanitarian law, and other domains. Now, there's no actual definition of disability in the treaty, believe it or not. There is no universal definition of disability, so it simply wasn't defined, but there's a sense of what we mean by disability in the treaty. So Article 1 of the treaty says that persons with disabilities include those who have long-term physical, mental, intellectual, or sensory impairments, which in interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. So Article 1 is not the definitions article in the treaty, but you get a sense that of disability there, and you get the clear sense that disability results not from some inherent deficit in an individual. This is not a medicalized notion of disability. Rather, this is a social model orientation of disability that recognizes barriers in society cause discrimination and create a whole variety of different barriers that stand in the way of human rights realization. So in the CRPD, we have for the first time a social model and human rights-based understanding of disability, along with core concepts like disability discrimination, reasonable accommodation, which is core to disability rights and is a part of the non-discrimination obligation. In other words, if reasonable accommodation is not provided to an individual with a disability, as long as it doesn't impose a disproportionate or undue burden, then that means that is a discrimination, right? The failure to provide reasonable accommodations is discrimination, which has applications for thinking about access to justice and for accounting for violations against people with disabilities. So I think at this point, I'll hand it over to the next set of questions.
Thank you so much, Janet, for providing such a comprehensive and concise framework for us to understand this discussion, both the history and reality, and of course the legal side as well. That's incredibly helpful. And now, I suppose, turning to connecting what Janet has now set out for us to the specific context of IHL and ICL, I'd like to turn to you now, Will, and discuss maybe one of the more notorious or well-known instances of targeting of disabled persons in the context of armed conflict, crimes against humanity. And I'm thinking specifically about the Holocaust perpetrated by the Nazi regime during World War II, and earlier enabling legislation in Germany, such as the 1933 law for the prevention of offspring with hereditary diseases, and as a result of which, among other groups, persons who were deemed to be disabled were targeted. So, Will, did the International Military Tribunal at Nuremberg or any of the subsequent trials conducted by Allied powers in Germany address crimes committed against the disabled population? And if so, was disability addressed as a legal concept or status by these judicial bodies?
Thank you so much for that question. And I think it may surprise most people, because it generally does, that the military tribunal on Nuremberg did directly recognize, charge, and convict individuals of crimes committed against persons with disabilities as crimes against humanity. The law that you referenced, the 1933 law, actually led to what maybe people are more familiar with in terms of a name, say the Nazi Achtung T4 program. This was the program that was otherwise known or termed as the euthanasia program. This enabled the systematic killing of babies, youth, adults, and older persons with disabilities, specifically for the purpose because they have a disability. So this very clear, We can see it as attorneys. We see and say, okay, they're targeting a population because of a specific characteristic and looking to eliminate them entirely. So this is what the military tribunal at Nuremberg was looking at, how to then charge it. What does it look like when we're charging this as them specifically targeting a population in systematic fashion? You can obviously sort of already guess, as I gave away the answer, that it was as a crimes against humanity. The indictments really came in the form of what I term, and others have termed, the so-called doctor trials. These are the individuals who were given the order to collect the persons with disabilities and to execute the euthanasia aspect, the killing of them. So what this looked like was there was 4 defendants, and the 4 of them were charged with crimes against humanity. Specifically, this is terminology from the charging document for, quote, systematic and secret execution of the aged, insane, incurably ill, of deformed children and other persons by gas, lethal injection, and diverse other means in nursing homes, hospitals, and asylums, end quote. Now, as Janet had stated in her introduction, it doesn't say persons with disabilities. It doesn't say we're targeting them, but this is because the language of the time, as Janet stated, is incurably ill, insane, deformed, these terms that are not CRP compliant, that are not persons first, they're not human rights based language. I mean, it's a reflection of the time, and we'll talk about this a little bit later when we talk about the Geneva Conventions and sort of their forming of how they reference persons with disabilities within it. But and this may be some of the reason why these 4 indictments and ultimately 3 convictions for crimes against humanity have been overlooked within ICL for so long, because based on my research and my work, there has not been another recognition of such crimes against humanity targeting persons with disabilities. And I'll sort of talk about this in a second, because it's not specific only to the Nazis. This didn't just happen during World War II. But I'm jumping ahead of myself, so give me a second. So of those 4 doctors that were indicted, 3 were convicted of crimes against humanity for that specific targeting and systematic killing of persons with disabilities in the variety of horrible ways that I described. What was also notable, actually, is that there was an indictment and a conviction of Wilhelm Frick in the Nazi leadership trial for crimes against humanity, for his involvement, really his overseeing of the T4 euthanasia program. Because as the charging document says, and the conviction says, is that, or the decision says, is that he was charged and found guilty of the oversight of nursing, quote, nursing homes, hospitals, and asylums in which euthanasia was practiced, and his knowledge that insane, sick, and aged people, quote, useless eaters, were being systematically put to death, but did not stop the murders, end quote. So it's really clear that the military tribunals at Nuremberg identified this as a systematic targeting of a civilian population based on their disability, and found it to be a crime against humanity in the early, the very early ages of crimes against humanity. But unfortunately, international criminal law has sort of subsequently forgotten about this recognition and the protection of persons with disabilities that go along with it. And this has led to a continuation of impunity for such crimes. And just to give some examples, because there's a second part to, I believe, the question, so I'll just jump ahead and answer it if you don't mind. As to, okay, so we know that this happened during the Holocaust, well documented, but really has it happened again? Is there targeting of persons with disabilities on a level that would fit into crimes against humanity in a similar way? And the answer is yes. But the problem is that just as we've seen crimes against humanity as, really not an important crime being elevated to a catch-all crime, the changing from, needing a nexus to a conflict to no longer needing a nexus has gone through an evolution. But throughout this entire evolution, it's forgotten its heritage, because examples like the Khmer Rouge, the Rwandan genocide, former Yugoslavia, Colombia, Syria, Iraq, are all instances where we can see And it's documented either by the CRPD committee, by Human Rights Watch, by just investigators generally, say for Rwanda and the Khmer Rouge, where individuals were targeted for killing because they were persons with disabilities. They were systematically killed, similar to how the Nazis were doing it, firing squads. I mean, it doesn't need to be right within a gas chamber, but the other aspect is that so more modern conflicts like Syria and Iraq see the targeted killings of persons with disabilities, the use of them as human shields, and the use and forced sterilization and other scientific experiments, maybe not so much, but using them as suicide bombers. And I'm going to sort of explain this because I think for us as attorneys, we need to understand that, because use of a human shield, suicide bombers, and such things. So in Colombia, there were quotas for the militaries in order to kill the certain number of rebel groups. If they couldn't meet their quota, there was a pushback from their commander to say you didn't do this because they can't report that then they killed X number of rebel fighters that day. So instead, in rural areas, they would go around, round up persons with intellectual disabilities generally or disabilities otherwise, put uniforms on them and kill them. Take photographs and call that filling up their quota. And what's interesting is that Colombia is an example that is well known and as a long-standing, and this is within the CRPD committee findings. So this is not some local individual with no credibility or something like that where we'd have to question it, but this is done in systematic investigations. The same with regards to Iraq and Syria, particularly persons with disabilities were used as human shields, and also individuals with intellectual disabilities were convinced, I guess, to conduct suicide bombing. This does need a bit more investigation, but the problem is that there's reporting at that level and then not seen. With regard to Khmer Rouge and Rwanda, again, systematic killing of persons with disabilities because of their disability. So really, you can see this legacy that started very promisingly at, addressing the aspect with regards to the T4 program, recognizing persons with disabilities as a population that can be targeted, and as such, the crimes committed against them can rise to the level of crime against humanity, but then sort of being forgotten. And to be honest, I don't know. I haven't been able to do that research further to sort of see where it sort of falls out. But really, you don't see it even in Yugoslavia when you're dealing with persons with disabilities who are POWs and their treatment. They really don't look at the fact that they're being denied medical treatment because they're persons with disabilities and therefore having a violation of the Geneva Conventions, but they look at it more just because of the fact that they're being denied the right, but not looking at the personality or individual characteristic of the individual of maybe why this is more impactful or why this person's being targeted over other POWs that are being held there. So really what's happening is there's not a holistic approach really to look at it to sort of do it, but that's also because most people don't know that there's a pretty strong jurisprudential history of showing that this is a crime against humanity and has been proven as such. So thank you.
Well, thanks so much for that insight, and I think I have no that many of us attending today we're not aware of some of the events you've described in these conflicts following post-World War II, and I think it's so important that we're having this discussion today, and that we're all aware of the precedent that does exist at the international level when it comes to the targeting of individuals with disability in these various contexts. So thank you so much for that. Christina, I would like to turn to you now.
Of course.
And so we've now gotten such a great historical overview, legal overview from Janet and from Will. And as a practitioner, as a disability advocate, it would be great to hear from you on what the realities and dangers are for disabled persons during times of armed conflict or natural or man-made disaster. And if you're able to provide any examples from some of the ongoing conflicts that I'm sure a lot of us are aware of today. I think that'd also be very helpful if that's a possibility. And connected to this, do principles of intersectionality have any relevance in your view in understanding the circumstances of disabled persons in these types of contexts?
It's a great question. I don't think you can discuss risks without discussing intersectionality. So in terms of risks, as Janet mentioned at the top of the discussion, if we think about the prejudices and discrimination that the disabled community encounters on a domestic level outside of periods of armed conflict, civil unrest, or humanitarian disasters, we know that disabled people are likely to encounter discrimination and challenges when it comes to accessing education, independent housing, medical care, legal rights, voting rights. We know this because domestic legislation in most parts of the world have attempted to address this. Whether or not that's then implemented into real life, real time and experience of disabled people is a different issue, but that's not for today. So if we then look at that in the context of a humanitarian crisis, so the UN has acknowledged, actually they acknowledged on the International Day of the Disabled Person just last year, that disabled people are, the challenges they face during periods of armed conflict are exacerbated by virtue of them being within that protected characteristic of the disabled community, and that they are, and I quote, most and first to be harmed. So if we really think about that, it's the capacity for harm as well as where they are in the list of those that are affected, the most and the first. And the way I look at it is this is the most vulnerable groups in our society, to which, as Janet also mentioned, 15% of the world's population belongs. And as I say in all discussions that I take part in when discussing disability, it's the fastest growing minority group to which anyone of any age, any gender, sexual orientation, or ethnic background, or in fact income background, can become a member of at any time. Disability can affect anyone at any time in their lives. So disabled people, the UN have acknowledged, are most and first to be harmed in situations of conflict. So if we think of why would this be, well, I think it's, to be honest, I think it's quite obvious that we've got the destruction of infrastructures. And this is also, when we look at it from a climate change perspective, as well as a civil unrest and armed conflict perspective, we've got the destruction of infrastructures, we've got the dismantling of critical support. If we give practical examples, and this comes from a report compiled by the International Disability Alliance, their report from April last year, taking examples from Ukraine, where there are power cuts, where there's mass bombings, destruction of buildings. To use an example, where are disabled people meant to go for their support? So if you have a wheelchair user who is dependent, let's say, on ramps within their abode, within their home, that's taken away. How are they able to maintain their independence? If they're separated from family, displacement, how are they meant to get the support they need? Those that are hard of hearing may be less likely to hear the surroundings that are taking place, may have been abandoned by family. And this actually, in the report, examples are provided not only of Ukraine, Gaza, CAR, and Syria, as we'll mention previously as well. So these are examples. You seem to be a common thread that takes place as to the vulnerabilities of disabled people in situations of humanitarian crisis. There are obvious human rights violations during this time. And just talking about my country, if we take a very recent global crisis, COVID, there was recently an inquiry within the UK about do not resuscitate orders that were broadly applied to disabled people during this time. And it was found that the individualistic approach of assessing it by patient basis was, for lack of a better phrase, thrown out of the window. And doctors, and in fact unqualified individuals, were given a free rein to issue DNR orders on disabled people admitted to hospital during the period of COVID, which really I think is a modern day reflection of the audacity with which disabled people are seen, the filter that they're seen seen of being less than worthy of the same care as their able-bodied counterparts. So if we then take intersectionality, and I think if I recall rightly, the UN Secretary Council in April 21, I think it was, specifically considered the impact of sexual and gender-based violence on women and girls in periods of armed conflict. And it was found that disabled women and girls were twice as likely to be victims of sexual violence during periods of armed conflict. So we've already there got that Venn diagram, that overlap of gender with disability, that intersectional point where we see that there's already there's many angles upon which prejudice is applied when it comes to armed conflict. I think, as Will mentioned previously, I think it's particularly true for women and young girls when it comes to their uses in sexual slavery. Disabled women and girls are seen as subhuman and therefore are more likely to be used as shields, as human shields, because they are seen as being subhuman during times of armed conflict. First to be left behind and most to be impacted, I think, is what I would like any of our audience members to take away today. But I think that's where I can, well, I'll also add as well, in terms of intersectionality and the different points that there are, obviously, poverty has a huge impact, whether or not there's a pre-existing infrastructure within that particular country as to access to assistance that disabled people may have had, obviously then is broken down by armed conflict or humanitarian crisis. That's economic background certainly has an impact. Gender, as we've already established, has an impact as well. So it's not good news, and it's very sad to see that it's not just one protected characteristic, but multiple then that lead to even further vulnerabilities, which is absolutely what the principles of intersectionality made us aware of. So I hope that assists.
No, that is indeed of great assistance, Christina, and thank you for just setting out so powerfully and starkly the situation of disabled persons in times of armed conflict or natural disaster, and the complexities that exist in that context as well. That's very much appreciated and really helps, I think, bring together the legal side with the practical side of our discussion. But now turning back to the legal side, and this is directed at Janet and Will as well. And given that we are all here interested in the topic of ICL in this context, what provisions of international humanitarian law and concepts of law may be of relevance for purposes of investigating and prosecuting alleged crimes impacting disabled persons, and for purposes of recognizing their status as disabled persons? And I think Will, you've already touched on this, but if Janet, you and Will, you could perhaps give us some more specifics on how IHL and ICL applies to our current topic.
Thank you. Well, I think Christina really nicely laid out the risks, right, that persons with disabilities experience, particularly in conflict and these kinds of contexts. So the challenge is, how do you sort of elevate and amplify risk experienced by people with disabilities without othering them, right? Without reinforcing paternalism and the very things that we're really trying to combat if we're taking a human rights-based approach to disability. And this was a massive challenge when we were drafting the Convention on the Rights of Persons with Disabilities. But there was yet this interest from the get-go in trying to tie in the protections that exist in international humanitarian law and other realms into the CRPD. So how do you go about doing that? So there's a really interesting provision in the CRPD which was quite controversial when we were drafting it, but nonetheless, we got it in, and that was Article 11. The framing is really important. Article 11 is titled Situations of Risk and Humanitarian Emergencies. So we were very conscious in how we would frame the struggles, right? And to try to do so not in a paternalistic way. And that provision reads, states parties shall take, in accordance with their obligations under international law, including international humanitarian law and international human rights law, all necessary measures to ensure the protection and safety of persons with disabilities in situations of risk, including situations of armed conflict, humanitarian emergencies, and the occurrence of natural disasters. So what that does is create linkages between the CRPD and its disability rights concepts and all of the other obligations that exist in international law, including international criminal law, which is not specifically referenced, but that's open-ended, right? So that gives us the opportunity to think about how the CRPD can inform these other domains of law. The good news is that is starting to happen in really exciting ways. So I think Will's going to talk more about how Article 11 is animating discussions about concepts in IHL and in international criminal law and how they can interact with concepts in the CRPD.
Thank you, Janet. Yeah, so what I think is important to state up front is that as Janet mentioned, Article 11 of the CRPD is unique in human rights treaties. The only other one that exists similarly connecting it to IHL directly would be the Convention on the Rights of the Child, directly requiring obligations as it relates to IHL and to the rights of the child to protect children during armed conflict. Article 11 is more vague, or more, I will say, more broad than that. Vague is a term that we could put to Article 11, but it's broad and vague in the sense that it talks about international humanitarian law and other areas of international law. So therefore, you can read it into international environmental law, international criminal law, so on and so forth. And the rationale behind it is obviously that, as Janet said at the beginning, persons with disabilities remain generally invisible within all aspects of international law outside of the CRPD. So what it's trying to do is spread itself in order to not overcome those other aspects of international law. Like the CRPD is not meant to replace ICL framework or the Geneva Conventions, but what it is meant to do is complement it as we understand international human rights law does to IHL and also international criminal law as practice dictates. So really what's also important is that the International Committee of the Red Cross, the UN Security Council via Resolution 2475, and the UN Special Rapporteur on the Rights of Persons with Disabilities all recognize this complementarity between the CRPD via Article 11 and IHL. The International Committee of the Red Cross has actually put out a briefing paper on it a couple of years ago, maybe more now, explaining how the provisions of the Geneva Conventions and additional protocols apply and include and consider persons with disabilities. And notably, I think for this group would be very important is the principle of adverse distinction within IHL. And this, as a principle, prohibits a negative treatment of an individual on the basis of the person's race, color, religion, faith, sex, birth, or wealth, or other similar characteristic. So as we know as lawyers, this is the catch-all phrase, other similar characteristics, disability fits within that. And it's not just me saying it. This is legal advisors at the International Committee of the Red Cross, the UN, state legal advisors that are on the Security Council as well, shown by Resolution 2475. So that's a really important aspect to understand that persons with disabilities fit under that other characteristic. It does need to be understood that this is similarly to what I was speaking about with regards to Nuremberg. The language used, we're talking about sick, wounded, infirmed, and maimed, or the combat. We understand that as an IHL, principle, but that does include persons with disabilities, right? A sick and wounded individual, I'm trying to put this in a way that makes sense of being a disability, you know, working in disability rights, but it's hard, right? Because the language matters to the disability community. It matters a lot. We're never going to change the language of the Geneva Conventions. Let's just accept that. But what needs to be understood is the understanding on the basis of it, meaning that someone's hors de combat, they're no longer participating within the conflict, either due to inability to do so or that they've surrendered. Okay, they are provided specific protections. The ICRC has said, and the Special Rapporteur has agreed, and UN Security Council as well, that this includes persons with disabilities, okay? So the trouble, I think, with IHL principles and saying, aha, here's a person, here it talks about persons with disabilities, is tough. You have to educate attorneys and judges and prosecutors to understand what these terms mean in practical, in practice, right? They may not see it as, oh, sick and wounded doesn't mean a person with a disability, but it absolutely does, right? If in the same way that most of us may not think that persons with disabilities can actively participate in armed conflict, and they absolutely can. They can be targeted when they directly participate in armed conflict because they have and they do. I actually did an article with a colleague who's an Islamic law expert, an IHL law expert, and we found really old references to persons with disabilities who are actively participating in conflict and are being given specific protections or not, in the sense if they're a combatant, right? They're not provided any special protections, but understanding that persons with disabilities are not always victims. They actively participate as well and can be criminals just as being victims of crime. So this is sort of a mind shift that really needs to occur. And in IHL, it's happening slowly. You have Security Council resolution. That's amazing. The ICRC has guidance on it. That's also amazing. But what really needs to happen, and the ICRC has done this, and the UN Special Rapporteur has also done this in his second report on the conduct of hostilities. You know, you have to dig down into it because it really sits in in GC4, the Geneva Convention 3 and 4. That requires specific respect and protection for persons with disabilities because it fits under the protection framework of wounded, sick, infirm, maimed, so on and so forth. So, you know, there are, you know, Article 30, you know, of GC3, article is mostly Article 30 that I found, but really just as for our purposes here, I'm not going to give an IHL a seminar on where this interacts. This would be by itself a number of hours long, and I would bring my colleagues from the ICRC as well in order to ensure I don't violate something, you know, make a mistake somewhere. But really what needs to understand is that the principle of adverse distinction applies. The language has to be looked at and understood in the modern understanding of disability, especially when we're talking about, as I stated before, POWs with disabilities, right? An individual who becomes hors de combat because of a wound is now a person with a disability and has specific protections that the CRPD will inform IHL on how to fulfill them, right? In terms of medical treatment, in terms of access to education, in terms of rehabilitation, in terms of repatriation, all these aspects are in helping inform IHL, and we're not there yet. We're getting close. And I think there needs to be serious discussions on how to do this. And just for all of us in the room, I think as well, it's very important to understand the obligation with regards to war crimes in particular, the obligation to suppress and repress. Okay, what I talked about earlier with regard to crimes against humanity also applies to war crimes. Persons with disabilities are the victims and targets of war crimes, as Christina said. Obviously, they are the first left behind and the most impacted. Therefore, more than likely, if you're having the potential of a war crime to be occur, it may be targeting specifically persons with disabilities. And with regards to that, you know, there's many barriers to the ICL system in terms of access to justice. If we're talking about a peaceful society, persons with disabilities have a base level problem accessing the justice system because there are physical and policy barriers put in their way that prevent them from being involved or accessing it. Colombia, again, is another good example where you may have to drive 4 hours in order to get to the area where you think is the Justice Ministry for reparations. And for persons with disabilities, that's expensive and hard, and they have to bring additional support, and it may take them all day just to be told that, oh, I'm sorry, you can't come in because there's no physical way for you to get in. We don't have a translator for you, sign language interpretation, certain ways that are very basic, even in a peaceful society or one not impacted by armed conflict or even natural disaster, that either completely disappear in terms of accessibility and additional barriers are put in place. So that was kind of an all-over answer, but but to really put it into context, IHL, you know, adverse distinction, suppress and repress obligations, and then access to justice within the ICL system are essential. They're moving. We're not there yet, but conversations like this are very encouraging, because very often we would never even have these conversations, maybe, you know, in my time even working on this topic, much less when Janet has been working on it, or Christina. So thank you.
Thank you so much, Janet and Will, for providing again some more detailed legal framework, definitions, and I think practical tools that those of us who are practitioners, I know certainly myself, from what all of you have said, that's something I'm going to take to heart and work into my processes as someone who represents, currently is representing victims before the ICC. So that is incredibly helpful, incredibly insightful. Thank you so much for that. And your last comment, Will, on accessibility to justice, I'd like to turn back to Christina now and connecting to that. Let's say in the criminal procedure, if we're talking about an ICL case, whether domestic or international or post-conflict, in respect of reparations for victims of international crimes, and in the context of assistance following armed conflict or disaster, could you address any particular difficulties or circumstances that should be recognized in ensuring equity and effectiveness in the provision of reparations and support for disabled individuals in this context? So things that we as practitioners should be aware of in this regard.
Of course. So I'm sure Janet will correct me if I'm wrong, but the CRPD was designed to emphasize inclusion and participation, and in fact, strengthen responses to exclusion when it came to disabled people. And the CRPD, forgive me, was also designed so disabled people were acknowledged as being full legal rights holders, and challenge the medical view that disability was something that needs to be cured or treated, as it were. So it attempted to bridge the gap between impairment, and I know that Will has discussed, and absolutely rightly so, that the terminology is really, it's everywhere, isn't it? But I'll use the term impairment for the moment, but to bridge the gap between impairment and social exclusion. But the CRPD is only as strong as its implementation. And I think that really is where the gaps as to how disabled people are to be able to access justice in accordance with Article 13 of the CRPD, that implementation at a domestic level and the practicalities of its implementation and the inconsistencies really will speak volumes for the reparations and disability involvement that there will be in rebuilding countries in a post-conflict situation. And unfortunately, that means challenging deeply entrenched for some nations. It means addressing deeply entrenched societal, institutional, and medical views of disability. We've got the stigmas of exactly what a disability is. What is an impairment? How has it come about? There's a lot of misguided belief as to disability being a sense of shame. As we already know, on an international level, disabled people, there's an epidemic of disabled people feeling isolation. And that was very much seen during COVID as well, a sense of a breakdown from their involvement in community, involvement in society. at every level. So those deeply entrenched institutional, medical, and societal views would need to be challenged head on, because without doing so, that nation simply isn't able to address disabled people's voices and have them involved in rebuilding the infrastructures, rebuilding their democracies in a post-conflict world, in a post-conflict situation. And I think those date back to, as Janet mentioned again at the top of this discussion, there's legislation that is quite far into the 20th century that reflects the way in which disabled people were viewed. And it's going to be a tough hill to climb, because those, without breaking those down and challenging them and addressing why is it that societies, why is it that institutions, why is it that medical practices in some parts of the world feel that disabled people need to be treated, that we should be hidden away, that there's a sense of shame, even on a micro level within families. Why is it that certain cultures are of the belief that disability stems from a curse, for instance, possession, for instance? It's these stigmas that then I think prevent disabled voices from being heard, even if they were to be invited into conversations surrounding the rebuilding of societies and communities in post-conflict. I hope that assists.
Thank you so much, Christina. I mean, you just enlightened us, I think, to the myriad issues that, again, we as practitioners and relevant institutions, the scholars who are working in the area of IHL and ICL, we all need to be aware of when addressing how to ensure the equitable inclusion of disabled persons, whether it's access to justice, access to reparations. This is something that we all need to include and be aware of and institutionalize in our work. Thank you so much for that. Very much appreciated. I see we're almost at the end of our time frame, and I wish we could have gone on even longer. Of course, there's so much more to discuss, but we're more or less on track, and I've reached my final question for all of you. And perhaps Janet, you could go first, perhaps, followed by Will, and then Christina. We are the ICC Bar Association, so turning specifically to the ICC, do you have any thoughts or recommendations on how the court and the Rome Statute framework can better address and take into account disability within its mandate and processes? So whether that's the Office of the Prosecutor, chambers of the court, the registry, the Independent Trust Fund for Victims, or even the Assembly of State Parties itself as the governing body for the Rome Statute framework. It'd be great to hear all of your thoughts on that. Thank you so much.
Thank you. I'll just say very briefly, I think we now have the foundation for moving forward. We have the CRPD. It's almost universally ratified. We have a Security Council Resolution 2475 that specifically talks about international accountability bodies being inclusive of people with disabilities. And I think the first step, in my view, would absolutely be the adoption of an ICC policy on disability, to bring things into alignment with policies on children, on women, etc. So that would be my big push. And over to Christina and Will.
Yeah, I just want to echo that as well. In my view, there needs to be creation of an OTP policy on persons with disabilities, the same way there has been for sexual and gender-based violence in children. But then also maybe a reflection back on those policies as well, and how to include persons with disabilities in them, understanding intersectionality, as Christina set forward for us, that, disability impacts women and girls, boys, men with disabilities differently than or in specifically different ways than would just be women and girls, say, with regards to sexual violence and other such things. The other aspect that I would like, this is somewhat a bit more problematic, is more of a restoration of the original recognition by the Nuremberg, tribunals to recognize either through practice or even a policy paper suggesting that recognizing that persons with disabilities, just as the UN has done and a number of other bodies, that persons with disabilities are targeted and victims of crimes against humanity and war crimes because of on the basis of their disability, and because of that, it needs to be something that is thought of when we're looking at recognition, investigation, charging, and prosecution, to really see the individual not just simply as a disability is not an issue, because that's something that was done with gender before. It was like, oh, it's just abuse, it's not a big deal, right? Rape, I guess, as a crime is now a war crime, so the evolution needs to continue, and I think it starts in practice first, but I think the policy and sort of a restoration of the jurisprudence would be helpful. So that's where I'll leave it and give Christina the last word.
Yeah, I entirely agree. I do think that the OTP at the ICC needs to give real due consideration to compiling a draft policy, or eventually a full policy, as to how to manage the issue of disability in the context of the Rome Statute. And I wonder whether that argument could be anchored by way of Article 13 of the CRPD, with how vitally important access to justice is, especially for those who are marginalised. I would say that it's almost a blind spot, as it were, for the ICC, in the absence of that advisory guidance, or at least a policy to go to that's been compiled in an appropriate way, which would then help matters moving forward. So yes, I think there's an argument to be made in terms of anchoring the need for a policy at the ICC by way of Article 13 of the CRPD, and also, obviously, as Will mentioned, the finding of the special rapporteur as well. So I agree entirely. Either an appointment of advisors or similar policies as to the policy for children and sexual and gender-based violence. I think it's absolutely correct and necessary, in fact. So yes, I echo the sentiments.
Thank you so much for those very specific recommendations in the context of the ICC. I think that's incredibly helpful. And in the event, the Office of the Prosecutor, maybe they shouldn't, in fact, be encouraged to start developing a policy in this area. And I certainly hope, if they do, that the three of you will be consulted and involved in that process. In principle, I know when the prosecutor's office issues draft policies, as all of you have mentioned, for example, on gender-based crimes and crimes against children, there is usually a consultation process involved in that. And certainly, I think as a bar association, I think that's certainly something that we'll have to consider putting on our own agenda. And thank you so much for your time today, Janet, Christina, and Will. We have reached the end of our panel discussion, so I think unfortunately we won't have time for additional questions at the moment. But this has been incredibly enlightening. You've given us the historical overview of sort of the concept of disability, the legal framework, both generally in a domestic sense, as well as in the context of international law, international criminal law, international humanitarian law, and also really brought home the realities of what disabled individuals face in their daily lives, in the context of conflict, natural disaster, and I think also really helpfully gotten to the complexities of how we think about disability and how we define that, whether it's just in our everyday lives or from a legal standpoint. So I really want to thank all three of you for making the time for this really important subject. I think it's important, and I know that many others will be able to watch this panel moving forward, this panel discussion. And many thanks as well to everyone who was able to tune in. today. So I want to wish you all a good rest of the day wherever you may be. Thank you so much.
Thank you.
Bye.
Bye.